I so find for the record, and he is guilty beyond a reasonable doubt. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 3 years. And of course, you will be given credit for all time you have served in accordance with this case. Anything else, Stay?
No, Judge.
Yes, Judge, just to make sure that I'm
Proper that you get credit for time you have served. You should never serve a day in jail and not get credit. Nick Bryanson. The 1 and 2 constitute a state jail felon, right? Paragraphs 1 and 2.
Yes.
And then he's got 2 state jails.
Talking about the original paragraph
the
and
bigger ones like that. Some paragraphs.
So that makes it a state jail felony punished as a 3rd degree, right?
yes, Judge.
So
He said.
you're Marcus Miles. In 25 CR 1635, what is it? Announcement.
Yes, Judge, Mr. Miles is dissatisfied with my services and would like a different lawyer.
So it has everything there.
Why?
And all the doctors.
Because I feel like
Go back.
I'm being incriminated
That's not the word.
and criminalized
That's not criminalized
criminalized
again.
with malicious intent. What? Man, I feel like because I'm.
Okay, well, he's not the one that brought the charge. The grand jury did.
I mean,
Not him. The grand jury brought this charge. He's trying to help you.
just so they did let me go.
Huh?
They did let me go from the house, and I didn't know which they told me the case had been dismissed. Your
Oh, but that's why God invented trials. They say there's an issue. They contend the indictment is correct. He says it's not right. You're not guilty. That's where we are on this. That means it goes to trial.
Judge, just for clarification, this case was re-indicted to correct one of the officer names in the indictment. So there was a dismissal and a re-indictment, but it's this re-indicted.
There was some mistaken words and then you re-indicted it
Yes.
to correct it?
And this active case is the re-indictment.
Well, all I've got is just this one, 25 CR 1635. That was
Because the other
Indicted
case has already been
October.
dismissed.
29, right?
Yes, Judge.
Okay. Yeah, that's what this is. But no, you don't get to, did you hire him? Or no, you can't just fire them like that. You can hire anybody you want and that's your choice with your money. But all you get under the law is a competent lawyer, which he is. He's a fighter. He fights for people.
Yeah.
But you don't get to change lawyers because the law has already been ruled on that. If you start that, you could do it all day long for the next 100 years, change lawyers, and we'd never get anything done. Well, the Supreme Court said that's not the way it works. You're entitled to a competent lawyer, and he's very competent. Now, I want to know, what do y'all want to do? Is there an offer that he's going to consider, or do we have to go to trial? That's all I need to know.
There's been one relayed, Judge.
Okay, and you related it to him, Brent?
I did, Judge.
And he says he wants a trial, which he has. That's what this Constitution says. You get a right to a trial. You don't get a right to a plea deal, but they still make plea deals. You don't have to take it, but this is your day. You got to tell me which direction you want to go. If you want a trial,
That's right.
you get it.
You know what, Your Honor? I'll sign for the plea. I'll sign for the plea.
I understand what he
That
said.
was-
Yours is the
Oh, the
Sign for
offer?
the-
Yeah.
I mean.
Okay. All right, we'll write it up, Brent.
Like two,
Write it up.
I did say two at first when I had my other lawyer.
Well, were you negotiating with them?
No, I've just been
I
on the
think that
case
was
with
Mr.
Brent.
When I had
Who?
my other lawyer,
David.
David A. Groves.
Okay. Well,
That was also not my case at that.
that's not her case, but that wasn't before me. It didn't come before me. So what happens is when they re-indict, I mean, it's a new game between lawyers.
I wasn't on the case, so I can't speak to whether.
Well, she said she's
They don't
after
have any
3 years.
notice
If y'all want to do that,
Yeah.
write it up so we can go. How long have you been in jail?
I've been in jail.
How much time is
As
this
far as
credit?
they say.
I'll tell you exactly. She'll tell you exactly. So you know where you stand. You get credit for all of that, Marcus. You know that.
Yes, sir.
You don't.
I'm just tired.
And then, yeah, and then you still get good time, and you're parolable. You'll get paroled at a certain time, and this is not an aggravated offense, so it's a quarter of the time. You could get parole in a quarter of the time. If it's 3, that's 36. You know, 4 into 36 is what? 9 months. That's what that's what you're gonna have to serve before you parole.
77 days.
You got 77 days, she says.
Judge, it's 120. I called the jail this morning. They had
He was-
the other case.
Yeah, he was
So they
rearrested.
brought it back to the other?
Yeah. They,
Okay.
it's probably to show on this current cause number. I talked to the jail this morning.
Yeah, that's an unofficial number.
Yeah.
I have to do more research when I get in the back of that and actually do.
I talked to Miss Katrina Keel.
Oh, okay, yeah.
She does-
Yes.
She was telling you how much credit he has?
Yes, sir. I called this morning. It's about 100.
Okay, whatever.
No, you're good. I know you're doing it now.
Yeah.
Sometimes they don't give them the,
I'm sorry.
at the end of the day, the jail people have the right numbers, not us. But they give us data and sometimes they don't update data.
Yes, sir.
All right, write it up and let me know when y'all are ready and we'll move it. Thanks. Joel Vasquez.
The court returns from a recess, expecting a final decision on self-representation. The defendant reverses course, stating he wants an attorney after discussing the matter with family members. This is a pivotal moment because it reveals uncertainty about proceeding without counsel after earlier confidence in self-representation.
25 CR 1635 is now called the State of Texas versus Marcus Miles. The defendant is present with Mr. Turk, his attorney, and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment here? Can we proceed in summary?
Yes, Judge.
In summary, Mr. Miles, this indictment alleges in paragraph 1 that on or about May 23rd, 2024, in Jefferson County, Texas, you committed the offense of evading arrest or detention. And in paragraph 2, it goes on to allege that you have 3 convictions previously of evading arrest or detentions. So, police officers. And paragraphs 1 and 2 thus constitute a state jail felony. Do you understand? But we go on to allege, they'll go on to allege you have 2 prior convictions of state jail felonies, one in 2014 in the 252nd District Court of Jefferson County for theft of stolen property, and then another one in this court in 2021 for illegal possession of a controlled substance. And did you fully review all of these allegations? So paragraphs 1 and 2 constitute a state jail felony. 3 and 4 enhance the state jail felony punishment to as though it were a 3rd-degree felony. You're punished as though a 3rd, but it will say state jail felony punished as a 3rd because of these additional convictions. So you are looking at no less than 2 nor more than 10 years confinement in prison and a fine up to $10,000 as the punishment range that is possible. Do you understand?
Yes, sir.
I tried to make it simpler this time, Judge.
You say 2 to 10, right?
Well, using English would have helped me. So this looks like Mayan.
It does, but after about 20 minutes
Hieroglyphics.
of trying to get that pen to work,
I
gave up.
look, I always been fun saying it. All right.
It just says enhanced to 3rd degree 2 to 10. I reviewed it with Mr. Miles. And since it's not a probation, I marked out those paragraphs, and since it's not a state jail punishment,
Okay.
I marked out that
So
one.
what I'm gonna do up here is state
No.
jail felony
To call this house.
punish as 3rd degree.
Yeah.
Offense. 336. And the agreement here, even though it's no less than 2 nor more than 10 years confinement in prison, the agreement is your sentence, you will be pleading guilty to paragraphs 1, 2, 3, and 4, sentenced to 3 years in prison, given credit for all time you have served. Is that your understanding of the plan?
Yes, Your Honor.
If I follow this agreement, you have no right of appeal of your case. Do you understand, sir?
Yes, Your Honor.
How do you plead to paragraph 1, guilty or not guilty of evading arrest or detention? Guilty.
Guilty. Guilty.
Paragraph 2, which goes on to allege those 3 prior convictions of evading arrest or detention, or are those allegations true and correct as they are alleged?
True.
And are you pleading true and correct to those allegations voluntarily?
Sir.
And finally, paragraphs 3 and 4, those prior convictions, state jail felonies in 252nd and in this criminal district court back in 2014 and 2021, are those allegations true and correct as they are alleged? And are you pleading true and correct to those allegations voluntarily and because they are true?
Yes, sir.
That constitutes, as you know, a state jail felony, though punished as though it were a 3rd-degree felony. Thus, the punishment range no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. And the agreement that's been reached with you and the state, you would be pleading guilty, sentenced to 3 years in prison. How do you plead to all of this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And then these paragraphs 2, 3, and 4 with those prior convictions, as we discussed, are those allegations all true and correct? And are you pleading true and correct to those allegations voluntarily and because they are indeed true?
Yes, sir.
I'm going to show you what's marked as State's Exhibit 1. Did you sign that document voluntarily, understand it, discuss it with your attorney? Are the contents all true and correct?
Yes.
State's Exhibit 1 tendered into evidence without objection admitted. This states you are mentally competent to enter your guilty pleas there, and pleas of true here. These are done freely and voluntarily. You understand and appreciate the consequences of pleading guilty. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true. It states so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived here.
Yes, Judge.
I will find as follows that the defendant is pleading guilty to paragraphs 1, 2, 3, and 4, which guilty to paragraph 1 and true to paragraphs 2, 3, and 4, which constitutes a state jail felony, punished though as a 3rd-degree felony. He is mentally competent to do so. He understands and appreciates the consequences of pleading guilty. There's sufficient evidence supporting his pleas of guilty and true to this state jail felony, punished as a 3rd-degree felony. From State's Exhibit 1, he has pleaded to and signed to support his guilty plea. That is enough to find the defendant guilty beyond a reasonable doubt of this state jail felony, punished as a 3rd-degree felony. I so find for the record, and he is guilty beyond a reasonable doubt. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 3 years. And of course, you will be given credit for all time you have served in accordance with this case. Anything else, State?
No, Judge.
Yes, Judge, just to make sure that I'm very sure the record's going to be clear, but I know since this was a re-indictment, I want to make sure that the record reflects that he should get credit from cause number 24 DCCR 1680, which I think in total, as per the Jefferson County Jail's
I
warning,
think it does.
is 120 days. Just making sure.
Yeah, you can't serve any time and not get credit for it. Somehow,
Well, I just want to
you got to put it together, and that's I believe the practice of the state. If there is a problem, call him up, raise it so we can fix it. But it's all fixable, but, because they're gonna be looking at different documents, it's still, it's only proper that you get credit for time you have served. You should never serve a day in jail and not get credit for it. Anybody, unless they did bad things.
They gotta, they have to, give me all of that. You gotta give you that, they gotta give you that every time.
Oh, I don't think there's a doubt about it. And if there's a problem, I can fix it.
Yeah.
Okay.
Serve the time in connection with this office.
I want to make sure since they're two different costs.
The case is not what we look at.
What was he indicted with the first time?
Same.
It was the same case. Yes, Judge.
Okay. Sometimes when there's different charges, they have a charge at the beginning, then they drop it. And sometimes that gets confusing, but it should not be a problem. It's the same charge. You gotta have credit. You gotta get credit for time you spend on a charge. Okay, anything else? That is all. Thank
That's
you.
After finding that probable cause existed for the traffic stop, the judge denies the motion to dismiss. The defendant immediately objects, prompting the judge to explain that objections do not change the ruling and that the proper remedy is appeal. This exchange captures a key legal principle. Disagreement with a ruling does not prevent the court from enforcing it.